Another way, third way by which one can acquire citizenship is by registration. So who all can become citizen by registration? For example, suppose there is a person of Indian origin who is ordinarily resident in India for 7 years, then he can make an application by which he can become a citizen by registration. So that means a person of Indian origin ordinarily resident in India for 7 years before making an application. Then another example you can take, suppose there is a person who is married to Indian citizen, then he or she can become Indian citizen by registration. Then another example is minor child of Indian citizen, of Indian parents. Then who else can become citizen by registration? Another example is, suppose there is a person who is registered as an overseas citizen of India card holder, then he or she can become citizen by registration. So OCI card holder, overseas citizen of India card holder, can also become Indian citizen by registration. So this is these are some examples by which one can become Indian citizen through registration. Next, we will read the fourth way by which one can become Indian citizen, and that is by naturalization. Now, if suppose there is a person who wants Indian citizenship through naturalization, then that person can get Indian citizenship by naturalization if this person is ordinarily residing in India for 12 years, and out of these 12 years this person must be living in India continuously for 1 year before making the application, and this 1 year should be continuous, and other 11 years that I am talking, and he stay in India 14 years before the previous to this 1 year comes out to be minimum 11 years. That means I am showing you by this diagram. Suppose this is date of application. So just before 1 year of date of application, this person must be living in India continuously. So suppose he is making an application 1st January 2022. Then immediately before this date 1 year, that means from 1st January 2021 to 1st January 2022, this person must be living in India continuously. And suppose this is 14 years. Out of this 14 years, this person must be living in India for 11 years. And out of the 14 years, that person must be living in India 11 years. And these 11 years, there is no necessity that these 11 years should be continuous. So that person can come to India, stay in India for some time, then again go back to abroad, then again come back to India. That person can do so. But in this 14 year, total 11 years, that person should stay in India. So out of 14 years, that person's total living in India should be 11 years. And in this 1 year, when that person will make the application, so before the date of application, prior to that, the previous 1 year, that person should not leave the country. That 1 year, that person should be continuously living in India. So in total, that person has to stay in India for 12 years. And out of these 12 years, immediately before the 1 year of date of application, that person should not leave the country. That means he should live in India continuously. And in this 14 year, he should as a whole in total should live in India 11 years. So 11 years plus 1 year, that means total 12 years. Then this person can become Indian citizen by naturalization. Then there are some other criteria. For example, suppose there is a person who is a citizen of any other country and not India. So he is a foreigner, he or she is a foreigner, and suppose this person wants Indian citizenship by naturalization. And then Indian government will give this person the citizenship by naturalization if he comes from such a country where Indians are also given, where Indians are not prevented citizenship by naturalization. For example, suppose there is a country X and this person belongs to country X, and this country X prevents Indian from taking citizenship of that country X. In that scenario, this person will not be given Indian citizenship by naturalization. That means the person is not a citizen of any country where citizens of India are prevented from becoming citizens by naturalization. This is one criteria. And another is that when this person will be given naturalization, when this person will be given citizenship by naturalization, then this person, after getting the Indian citizenship, should renounce the citizenship of other country, because India does not permit dual citizenship. Then this person, another criteria is that this person should have adequate knowledge of a language which is specified in 8th schedule of Indian Constitution. And in 8th schedule 22 languages are mentioned. So out of these 22 languages, that person should have an adequate knowledge of any of the language mentioned in 8th schedule. And then another criteria is that this person's intention should be to reside in India after getting the citizenship by naturalization. So I am repeating the criteria. So that person who wants Indian citizenship by naturalization, that person should not be from any country where citizens of India are prevented from becoming citizens by naturalization. Then another thing is that when that person will be given the Indian citizenship by naturalization, that person should renounce the citizenship of other country, because India does not allow dual citizenship. Then that person should have adequate knowledge of a language that is specified in the 8th schedule of Indian Constitution, which contains 22 languages. And that person's intention should be clear to reside in India after naturalization. So this is Indian citizenship acquisition by naturalization. But let me tell you one thing here, that if the central government thinks, then the central government may waive all these conditions for naturalization or few of these conditions for naturalization in case of a person who has rendered distinguished service to either science or philosophy, art, literature, world peace, or human progress. And when I say central government, that means here in this case it is Ministry of Home Affairs. So Ministry of Home Affairs may waive all or few conditions for naturalization in case if there is a person who has rendered distinguished service to science, philosophy, art, literature, world peace, or human progress. And next is by incorporation of territory. Suppose there is any territory and that territory becomes part of India. Then Government of India shall specify that who will be those persons of that territory who shall be the citizen of India. That means suppose if tomorrow any territory becomes part of India, that does not mean automatically that all the persons living in that territory will become citizen of India. Government of India should specify that who shall become citizen of India in that territory that becomes part of India. That means when a territory becomes a part of India, that does not automatically mean all the persons become a citizen of India. It is Government of India who shall specify the persons of that territory who shall become citizen of India. So this is the fifth way by which Indian citizenship can be acquired, that is by incorporation of territory. Now we'll read loss of citizenship, and there are three ways by which Indian citizenship can be lost. And the first way by which Indian citizenship can be lost is by renunciation. Suppose there is a person, and this person has acquired citizenship of other country. Suppose this person is an Indian citizen and this person has acquired citizenship of other country, and he gives up his or her Indian citizenship. That means this person earlier was an Indian citizen. Now somehow this person has acquired citizenship of other country, and when this person has acquired the citizenship of other country, he or she gives up his or her Indian citizenship. This is called renunciation, and this is a voluntary act. That means this person has acquired the citizenship of other country and this person is giving up the Indian citizen voluntarily. So this is loss of Indian citizenship by renunciation. Now one thing here I need to mention is that when this person renounces his or her Indian citizenship, suppose this person has minor child. So when this person is giving up his Indian citizenship by renunciation, at that moment, let's assume this person has minor child. Then at that moment when this person is giving up the Indian citizenship, his or her minor child also loses Indian citizenship. But this minor child, when he will attain full age, 18 years of age, this minor child will have option to resume his Indian citizenship, and that can be acquired by registration. That I have already told you when I was teaching you by registration. Now next way is by termination. Now this happens by operation of law. That means let's suppose there is a person and who is a citizen of India. Now this person voluntarily acquires citizenship of other country. Then what will happen? This person's Indian citizenship will automatically be terminated. So this person's Indian citizenship automatically will be terminated. So when this person, suppose this person is an Indian citizen and this person voluntarily acquires the citizenship of other country, then what will happen? This person's Indian citizenship will be automatically terminated. This is loss of citizenship by termination. Next is by deprivation. Deprivation is compulsory termination of citizenship. So this is compulsory termination of citizenship by central government. So this is loss of Indian citizenship by deprivation. This is nothing but compulsory termination by central government. Now let's see the condition when a person can lose his or her Indian citizenship by deprivation. One condition is that suppose there is a person who has acquired Indian citizenship by fraud. That means let's assume this person was not an Indian citizen originally, and this person somehow, either by registration or by naturalization, let's assume this person earlier got Indian citizenship. Now it comes out in light that this person acquired Indian citizenship by fraud or by false representation or by false representation of facts, That means this person somehow acquired Indian citizenship, but now it has come to light that this person got the Indian citizenship by fraud, by false representation of facts. Then this person's citizenship can be lost by deprivation. Or let's assume, suppose there is a person who is Indian citizen who is showing his disloyalty to Indian constitution. So suppose this person is disloyal to Indian constitution, then this person's citizenship can be lost by deprivation. Or another condition is, let's assume there is a person who is Indian citizen, but this Indian citizen is ordinarily residing out of India for 7 years continuously. So then in that case, this person's citizenship can be lost. But there is an exception to this. The exception is that suppose this person is a student who is living in abroad, then this 7-year criteria is not applicable to this student. That means even if a student is ordinarily residing out of India continuously for 7 years, then also that student's Indian citizenship will not be lost. So this was loss of Indian citizenship by deprivation, and earlier we have already read about termination and renunciation. Now we'll read about the amendment of Citizenship Amendment Act that happened in 2015. So in 2015 an amendment to Citizenship Act happened, and what happened earlier, there was two separate schemes. One was person of Indian origin scheme, PIO, and another one was overseas citizen of India. In 2015 both these were merged, and now the name of the scheme is Overseas Citizen of India Card Holder. And in this context, let me tell you one thing, that OCI, Overseas Citizen of India Card Holder, is not an Indian citizen, but non-resident Indian, that is NRI, is Indian citizen. And I have told you that Overseas Citizen of India Card Holder can become Indian citizen, but NRI is already, non-resident Indian is already a Indian citizen. Now this Citizenship Act has been amended in 2019 as well, and here the provisions of the act is such that it says that the Hindus, Sikhs, Buddhists, Jains, Parsis and Christians, these 6 communities, persons of these 6 communities from 3 countries, Afghanistan, Bangladesh and Pakistan. So the persons belonging to Hindus, Sikhs, Buddhists, Jains, Parsis and Christians from 3 countries, Afghanistan, Bangladesh and Pakistan, will not be treated as illegal migrant. So will not be treated as illegal migrant who have entered India on or before 31st December 2014. So this is the provision, and the other provisions are such that those persons belonging to Hindus, Sikhs, Buddhists, Jains, Parsis and Christians from these 3 countries, these persons shall be deemed to be citizen of India from the date of their entry. So they will be deemed to be citizen of India from the date of their entry into India. And another thing is that all the legal proceedings that was going against them in respect of their illegal migration thing or citizenship thing, then that legal proceedings will be closed now. So there will not be any legal proceedings for them. And when I was teaching you that how to get Indian citizenship by naturalization, that time I told you that there is a 11-year period, but this amendment of 2019 says that this period of naturalization of 11 years is reduced to 5 years for Hindus, Sikhs, Buddhists, Jains, Parsis and Christians coming from Afghanistan, Bangladesh and Pakistan. So these are the main provisions of the Citizenship Amendment Act 2019.